Legal and ethical considerations. Understanding the legal and ethical issues in healthcare are important to all nurses, but patients with mental health concerns elevate the significance of this understanding due to alterations in thought, mood, and or behavior that may impact their decision-making capacity. These patients are often vulnerable and may need to have their rights protected through the legal system. So ethics. This is the study of philosophical beliefs about what is considered right or wrong in a society. Bioethics are used in relation to ethical dilemmas surrounding healthcare, and an ethical dilemma is a conflict between two or more courses of action, each with favorable and unfavorable consequences. So there are 6 principles of bioethics, and you talked about these in fundamentals course. You have autonomy, which is respecting the rights of others to make their own decisions. For example, the right to refuse a treatment or the right to refuse a medication. Beneficence is the duty to promote good. Now, maleficence is doing no harm to the patient. Justice is to distribute resources or care equally. Fidelity, maintaining loyalty and commitment, doing no wrong to a patient. And finally, veracity is one's duty to always communicate truthfully. The American Nurses Association has a code of ethics that you'll find on box 6.1 on page 93 of your textbook. So evolving ethical issues in psychiatric care. The first is pharmacogenetic testing. It can be used to help identify which medications are most helpful based on DNA with the goal to eliminate trial and error. Has been used for about 10 years for antidepressants, but there's an issue of non-maleficence. Patients are potentially being harmed if the test and results are not useful, as well as questionable ethics justifying the cost of this. There's predictive psychiatry, which is genetic testing to determine psychiatric disorders. There's a stigma with it though. An individual possibly losing their job because of a mental illness. Consequences for insurance, employment, and discrimination just in general. Issue of autonomy. There's a fine line issue of autonomy. There's a fine line for who can know if they are carriers for a certain disease within a family. Others in the family may not want to know that information. And then genome scans. Since the development of at-home kits, people are now reading results without healthcare providers present to discuss and explain information, as well as provide education. So are more patients experiencing emotional distress because of that? And you should note that your physiology can change simply based on knowing you have a genetic risk. Hospital admission procedures. Sometimes a patient needs more care than what an outpatient facility can provide due to severity of symptoms and the need to be closely monitored. So there's voluntary admission and involuntary commitment. Voluntary admission is when it is sought out by the patient or the guardian. People under 16 may need a parent or legal guardian to have authority, and those between 16 and 18 may seek treatment independently. These patients have the right to request release, and reevaluation may be necessary before discharge. So even though you were voluntary, just because you want to go home, you may have to be evaluated to see if it's safe that you leave. These patients need to give informed consent. But then you have involuntary commitment. It's also called assisted inpatient psychiatric treatment. Involuntary commitment is court-ordered and it is without the patient's consent, but the patient still has the right to informed consent. Standards for admission include a diagnosis of mental illness, if the patient is a danger to self or others, if the patient is gravely disabled and unable to take care of basic needs, or if the patient is in need of treatment and the mental illness prevents them from seeking the necessary treatment. Now, involuntary committed patients cannot be held for more than 72 hours without a panel of healthcare professionals reviewing the case. Writ of habeas corpus is a petition that can be filed by the patient that means free the person. So if the patient does not believe that they should be involuntarily committed, they can file for a writ of habeas corpus to ask to be released. These patients still deserve the least restrictive alternative document that serves the healthcare professionals are taking the least drastic measure to help the patient. Emergency commitment is used for patients that are so confused they are unable to make decisions on their own, or for those that are so ill they need emergency care. The psychiatrist at the receiving facility should confirm the emergency commitment, and the purpose of this is to observe, diagnose, and treat. The patient will be held for 24 to 96 hours, depending on state law, and may require a court hearing before discharge or next admission. Which individual may need involuntary hospitalization? C. An individual with bipolar disorder, manic phase, who has not eaten in 4 days because they are mentally ill, a danger to themselves or others, and they're unable to provide for their own basic care. Discharge procedures. Unconditional release is the most common type of discharge. It is a termination of the legal patient-institution relationship. Then there is release against medical advice, AMA, and this is when a patient says, you know what, I know you say that I shouldn't go home, I need to be here, but I don't care, I don't want to be here, so I'm leaving. And if they're not involuntarily committed, you have to let them leave, but you need to try to get them to sign an AMA form, which basically states, I understand that it is against medical advice that I leave. I need to be here for treatment, but I'm making the decision to leave anyway. Conditional release usually requires outpatient treatment for a specified period of time with follow-up evaluations. And then assisted outpatient treatment is similar to conditional release, but it is court-ordered and often used to reduce hospitalization, but also used as a preventative measure. So patients' rights under the law. Patients are given a written copy of their basic rights. It does not matter if you're going to the doctor's office, the hospital, or a psychiatric facility. All patients are given a written copy of their basic rights. So you have the right to treatment. These patients have the right to receive quality care, of which you can see the bullet points here. They have the right to be free from excessive or unnecessary medication, the right to privacy and dignity, the right to the least restrictive environment, the right to an attorney, clergy, or private care provider, the right to not be subjected to lobotomies, electroconvulsive treatments, ECT, and other treatments without fully informed consent. They have the right to refuse treatment. Patients can choose to withhold consent or withdraw consent at any time, so just because you give it doesn't mean you can't take it back. Even if they are involuntarily committed, they have the right to refuse treatment. Now, there is some discrepancy as pharmacologic measures alter the patient's mental ability. So the question is, okay, are they mentally well enough if they've taken something that slows down their thought processes to make these decisions? The table here, 6.1, give you evolution of some cases that you can read through. Now, note that medication can be given in an emergency situation without a court hearing or after a court hearing if they meet certain criteria. And that is here. This is if the person has a serious mental illness, the person's functioning is deteriorating, and the person is suffering or exhibiting a threatening behavior. The benefits of treatment outweigh the harm. the person lacks the capacity to make a reasoned decision about the treatment, and the least restrictive services have been found to be inadequate. Now, right to informed consent, the patient should be informed of risks, benefits, and alternatives, and they must voluntarily accept treatment. Now, implied consent is an example of implied consent is giving a patient medication and they willingly take it. But then we need to establish capacity and competency. Capacity is the patient's ability to understand and make an informed decision. Competency is the degree of mental soundness a person has to make decisions and carry out specific acts. J.S., a 27-year-old male, is court committed by his parents to your unit with a diagnosis of paranoid schizophrenia. He lashes out at staff when they attempt to give him his medications. He states, "You are trying to poison me." J.S. continues to argue with staff. He is not aggressive, but refuses all treatment. Legal and client's rights are suspended when a client is hospitalized involuntarily. The answer is B, false. Involuntary admission requires that the client retain freedom from unreasonable bodily restraints, the right to informed consent, and the right to refuse medications. The family of J.S. asks, if you can force him to take his medications, how should you respond? Patients who have been committed retain their right to refuse treatment. However, in an emergency, to prevent a person from causing serious and imminent harm to themselves or others, the individual may be medicated without a court hearing. Following a court hearing, a person can be medicated if they meet the criteria that we discussed earlier. Eventually, J.S. agrees to electroconvulsive therapy. Which member of the team is responsible for obtaining the client's informed consent? A. The physician or advanced practice provider must obtain the informed consent form from the patient for it to be legal. So patients' rights under the law continue. Rights regarding psychiatric advance directives. These are created when the patient is well. So we have an obligation to honor the rights of self-determination, and an advanced psychiatric directive supports that goal. It must be written while the patient is in a healthy mind frame so it can be carried out when they are not in a healthy mind frame. Rights regarding restraint and seclusion. Physical restraints include holding or using a device to prevent movement. Chemical restraints include medications. Seclusion is confining the patient to a room or area alone and preventing them from leaving. Before applying restraints, nurses should verbally intervene, reduce stimulation, actively listen, provide a diversion, and offer PRN medications. Restraints are never written as PRN orders. Time limits for restraints. So 18 years old and up are limited to 4 hours, 9 to 17-year-olds are limited to 2, and under 9 are limited to 1. Documentation of time placed and time released is critical. And in an emergency, the nurse may place the patient in restraints and then obtain the order within 1 hour. It will be very helpful for you to become very familiar with this restraint and seclusion section, as it will be referenced in multiple chapters throughout the semester. Rights regarding confidentiality. Confidentiality is an ethical responsibility of all healthcare professionals. We've all heard of HIPAA, Health Insurance Portability and Accountability Act. HIPAA means that you cannot release information without consent without the consent of the patient except to those persons who are necessary in the treatment of the patient. Confidentiality in social media. The internet is not confidential and is open to the possibility of legal subpoenas. Confidentiality after death. You cannot release information that could not be shared when the patient was alive. Confidentiality of professional communication. Legal privilege to ensure that patients will speak frankly and willingly disclose personal information about themselves without fear of being repeated or distributed. Exceptions. There's always exceptions. Duty to warn and protect third parties. This is warning another that they may be in danger from a patient. Abuse. Laws vary from state to state, but all have laws on reporting. Nurses are mandated reporters of abuse. Failure to protect patients. Miscommunication and medication errors can occur. Self-harm is another risk in psychiatric nursing. Sexual misconduct between the patient and the healthcare worker is also another area of liability. Tort law. A tort is any wrongful act, whether it's intentional or accidental, that results in injury to another person. An intentional tort is the willful or intentional acts that violate another person's rights or property. Assault is an intentional threat to do harm. Battery is when actual harm occurs to another person, such as when you shove them or you give them an injection when they refused it. False imprisonment is confining a person to a limited area. Unintentional tort is unintended acts against another person that produce injury or harm. Negligence is the most common. It is a failure to act accordingly in professional practice. And malpractice is a special type of negligence with 5 required elements that we'll talk about on the next slide. So duty is the accepted responsibility of duty as a competent nurse. Breach of duty is falling below the standard of care and exposing a patient to an unreasonable risk of harm. It can be an act of commission or omission. Cause in fact and proximate cause would harm have occurred if it were not for what the nurse did or did not do. Proximate cause is legal cause to evaluate if there were actions or persons that caused the harm. And damages are actual and consequential damages. So standards for nursing care. All nurses are held to the same standard of care as other nurses who possess the same degree of skills and knowledge in the same circumstances would do. So the State Board of Nursing regulates state nurse practice acts in order to protect the public. Each state has its own Nurse Practice Act. Professional associations set standards of excellence. The 2 main associations for psychiatric nurses are the American Nurses Association and the American Psychiatric Nurses Association. Institutional policies and procedures define criteria for care, but must follow state board regulations. And custom as a standard of care. When there is no written policy available, it should be used with caution, and we must follow all standards of care. Which of the following identifies the titles that registered nurses will use and what they are legally allowed to do? A. The state boards of nursing. So acting on questionable practice refers to, or relates to nurses reporting a colleague. This can be due to negligence, irresponsibility, or they may be impaired while at work. We have a duty to intervene and a duty to report anything that is a nurse who is incompetent, impaired, or any criminal activity. In the reporting process, you need to document clearly and accurately first, and then the supervisor will intervene, and if unavailable, you must intervene to protect the patient. Documentation of care. A record's usefulness is determined by how accurately and completely it portrays the patient's behavioral status at the time it was written. These documents are legal documents and they can be used as evidence. The patient does have the right to view the record, but the record belongs to the institution. Now, there are times when it will be important to use the patient's own words in your documentation. When you do this, you should use quotation marks. This will show attention to detail and reflections of the patient's thoughts and conditions. And then there are retrospective record reviews. These are used for quality improvement, used as evidence, used for risk management purposes, and they're used to determine insurance reimbursements. So guidelines for electronic documentation. This manages data and communication. It reduces errors and facilitates decision making. There are federal privacy laws on access. If you were not actively caring for a patient, you should not be in their record. Courts assume if it is not documented, it did not happen. And there are specific rules and time frames for correcting errors, and you need to follow the guidelines for your facility. Forensic nursing. This is the application of nursing principles in a court of law to assist a decision by the courts. The nurse often educates the courts on the science of nursing, and they may provide opinions using appropriate nursing standards. Issues at stake could include patient competency, the individual's fitness to stand trial, involuntary commitment, and the responsibility for a crime. And finally, violence in the psychiatric setting. Nurses must participate in setting policies that create and maintain a safe environment. Always make sure to document the patient's potential for violence, communicate observations to your colleagues, and know that new laws enhance criminal charges and penalties for striking nurses and other healthcare workers in the course of duty.